So we all know who I am, so we don't need to reintroduce that. Okay, everybody sees the slides, right? Yeah.
Yes. And
Okay.
Sandy, this is Carissa. I am here.
Oh, hi, Carissa. Okay, I'm still going to record anyways because
That's
we're trying
perfect.
to.
I'm driving, so
I'm
that's
trying to
perfect.
archive everything. And
Okay.
yeah, if my camera goes back down to my cleavage, just please, everybody, let me know. Okay.
I
Um,
took a screenshot over the first time, so it's fine.
it's got a mind of its own these days. I don't know.
Yeah.
Okay, so as some of you may know, I'm a certified divorce lending professional. This is a version of um, alternative financing where you're still in the Fannie Freddie FHA market, but a way where guidelines change because of court orders. So what is actually divorce mortgage planning? Well, it's the ability to be able to put into play the desired outcome by pairing the needs and options available and still incorporate necessary details into an executable settlement between the divorcing couples, their attorneys, and hopefully with the mortgage broker as well, because we need to get involved to make sure that we can keep the people qualified to either retain the marital home or be able to sell it and move forward in another home. And today, actually last night when I was driving back from camp, I got this email and I was at a rest stop and I looked at it and I was like, what in the hell? How can this possibly even pass a high cost? The rate was 5.25. The points to the lender was 5.85 points just to get that interest rate. And then on top of it, the broker was charging another 2 points. So we all know that we're exceeding that 5% area in box A. And how do you get around it? And one of the ways to get around it is if you have the seller paying part of those points where you're buying down the rate. Fortunately, I knew immediately that this estimate came from UWM. I called up our rep at UWM and I said, how can you allow this to go out like this? Isn't there a stop button on your end to prevent people from manipulating the system? Unfortunately, there isn't, but it got even more complicated today because the way the loan originator structured this, she has structured it as the woman being a straw buyer. Does anybody know what a straw buyer is? Anybody? Okay, so anybody want to take a guess at what a straw buyer is?
It's not legal, right? It's someone who's
It's not, it's a gray area, Annette. It technically is not legal. So it's when, let's say somebody has bad credit and they want to save their house, but they can't qualify. So they sell their house to a family member who stands in and then rents the house back to them. That is a version of a straw buyer. They have no intention of leaving the property, but they can't qualify to refinance or purchase the property. So they get somebody else that will do that. And normally, it's seen the most when people are going into a foreclosure and they're trying to save their house. So they get somebody to buy the house for them, or they just have really bad credit and they can't qualify to refinance to pull the equity out, which is not the case. The actual person that owns the property, who was told he had to sell it to his cousin to keep it, actually has an 800 FICO score. He's self-employed. The safer way to have done this was to have his cousin go on title with him as a non-occupying co-signer so that nobody is specifically could be accused of committing fraud. And so it's not that the loan originator did a terrible job. I'm not going to sit here and trash her. You don't know what you don't know, because she doesn't understand that a lot of things with divorce and financing goes along the terms of no cash out guidelines, not cash out guidelines. And so we're going to go through that a little bit today. And I'll be fixing that situation and changing it so that they are not doing a fraudulent transaction to get the equity to pay his ex-wife. We're going to do it the right way. And so I feel that it's really important to share some of this information with everybody. If you want to become a certified divorce lending professional, I will refer you to where you have to go to do the training. It is extensive training. It's 2 coaching calls a week. You work with attorneys. You have to take CE classes. And you know, it takes a lot to get it going, but if it's an area that you're all interested in, I will give you the information of the person that does the training to get you on the road to doing that. So what I do is kind of a collaborative divorce. So we're looking for a successful divorce. And I know that sounds a little weird, but there are actually successful divorces. So you have divorce law that you have to look at. You have the IRS tax laws, you have real estate, and you have the mortgage financing. So when you split it into 4 sections, it seems pretty seamless, pretty easy. But there are areas where it becomes intermingled and it gets a little bit more complicated. And this is where giving you some of the tools that we have will help uncomplicate things. So while a typical mortgage professional simply is going to help you complete paperwork and ensure your application is processed, when you're in the divorce lending profession, you're going to be working directly with that divorce team, with the attorneys, with both sides of the party. You have your fiduciary responsibility is to the transaction, not to individual people. You have to stay neutral at all times with these things. How can I want to keep these things in mind? How can I keep the house? Can I assume the existing mortgage? Can I buy a new house while this is going on? Can I sell the house and be able to buy another house? And if I'm not on the current mortgage or on title, but the house is awarded to me, can I refinance that house? And so there are different things that we have in our guidelines that will make this work. So now we've gone for, we want to vet the house, meaning we're going to take an examination of the ownership of property. So we're going to look at title. Who is in title on the house? Are you both on title? Are you both on the mortgage? Is only one of you on mortgage? Is only one of you on title? So how the house is vested is very important. We then have to kind of look at income sources. And this is where it can get maybe a little bit more complicated. It's not always black and white, because when you're going through a divorce, there are new income sources that come into play that people are not utilizing that can be utilized. And so we're going to talk about that. Consumer debt. We are under the assumption that if you are joint owners on a credit card, even if you get divorced, and that credit card is the responsibility of one partner and not the other, that you still have to count it into your debt ratio. And that is a misconception. That is not true. Same thing with the mortgage. Let's say you're both on the mortgage and the house is being awarded to the wife, and it is now going to be her responsibility to make that mortgage payment. If it is documented in your divorce stipulation, we call that a court-ordered loan assumption, meaning that all you have to do is notify the lender that you are now in charge of making the mortgage payments, and all of those statements have to come to you. It's not taking the other person off. They're still going to be on the mortgage, okay? So if you mess up, you're not going to just mess up your credit score, you're going to mess up theirs too. So this is usually a temporary solution, because we have timelines that we all know. And Fannie Mae recently added that you cannot refinance a cash out for 12 months after title has been transferred over. You can do a no cash out. You can do a gift of equity. There are other ways around their new guideline changes. So let's take a look at these one at a time. I'm going to skip over anything that's a little bit more involved that really is not going to affect us here, like Quadros, which has to do with 401ks, other than to say this. If in a divorce, there is a 401k and it is going to be split, that money from the 401k can actually be put into a revocable trust and can then be used as income to qualify to either refinance and keep the marital property, or to use so that when you're ready to purchase a new home, you can use it as income. Revocable trusts are a wonderful tool in our industry because you only have to receive one payment and it has to go forward for 3 years. So for example, let's say there was $1 million in your 401k and your divorce says you're getting half of it. So you're getting 500,000. You can take that 500,000, put it in a revocable trust, and let's say you need $10,000 a month to qualify for that mortgage payment. You will be able to just take one payment of 10,000. That is your income, 10,000 a month now. And because there is more than 3 years left over in that revocable trust, you can go Fannie, Freddie, FHA. So revocable trusts can be very valuable. So one thing that you need to understand, if you're talking to somebody and they tell you, I'm thinking of getting divorced, I want my house, I want this, people are very open, they tell us things. The best advice that you will be able to give anybody that openly tells you they're considering getting divorced is to continue making all of their credit and mortgage payments. By stopping those payments because you're mad is not going to hurt your spouse, it's going to hurt both of you. So it's very important that they be prepared if they're going to go for a divorce. And one of the biggest challenges that people have is the lack of knowledge and understanding to be prepared. I gotta just plug this in over here. Sorry, guys. So to be prepared. So some divorcing consumers already have an understanding of credit, but unfortunately, there are still some people that on one side of a marriage took care of all of the bills, all of the finances, while the other party maybe took care of the kids and the house. And I know that a lot of people separate the things, but they need to be able to understand that they have to have a pulse on their finances, on what their credit card balances are. And if they're going to get divorced, they need to take pictures of their credit cards that they have together and stop using them. Don't close them, make the minimum payments. The courts are going to decide who is responsible for the credit card payments. But until they make that decision, you don't want to be charging on joint credit cards, and you don't want to be closing anything. You just want to put those credit cards aside, take pictures, and make sure, even if it wasn't your responsibility, that the bills are being paid on time every month. I can't stress that enough, because people like to get back at each other, and the first place they do it is, I'm not making the mortgage payment. I'm not paying that credit card. You charge that credit card up. If you are joined on these things, by not making those payments, you are hurting each other, and you are not going to become whole. They're not going to be whole after a divorce. So we have to manage that joint debt and the consumer credit, and they need to understand what the makeup of their credit score is. So let's say they are an assigned authorized user, but they don't have any of their own credit. Once that divorce goes through, obviously, as an authorized user, they're going to be removed from those credit card accounts if they're not held responsible. And so now they're not going to have a credit score anymore. So that's when they may need to start rebuilding their credit. So you don't want to tell them to open new credit cards. We don't want them doing that, but they may need to get into a position where they will have to establish their own credit. And so if they start making the payments on those accounts and they're on time every month, if they're in charge of them, then they may have to like eventually have them assigned over. So poor credit is going to make it harder to get car loans, home loans, qualify for any kind of credit card payments. So if you get in front of somebody when they're just in the beginning stages of thinking about it, you have the opportunity to give them some really valuable advice about their joint credit that they have together. So go ahead.
Can I ask a question? So if can you hear me?
Yeah, you're breaking up a little bit, Carissa.
Is this better?
Yeah.
Okay. If you were to have like, I know you said not to take out any other credit cards, but what if, you know, like if stay-at-home mom and she needs to establish credit because she doesn't have any, would you recommend she just take out a card in her own name?
Yes, I would recommend that. If she knows that she's going to be making a strategic move in the future and he doesn't know about it, I would absolutely advise her to take out her own credit card.
But it would be kind of, because she wouldn't be able to file any, you know, she'd get a like a certified credit card through her bank or something.
Secured credit card. So if he's like the main income holder, it gets a little bit more complicated if he's had the upper hand, or, and I shouldn't say he or she has the upper hand and he's been taking care of all of the credit card payments and the mortgage payments, and he's the only one bringing income in. And, you know, she took on that true role of, you know, homemaker. It might be a little bit more difficult to get a regular credit card because she doesn't have any of her own income. But what she does have control of is if she's, you know, has money, access to any money where she could do a secured credit and start doing that. Now, you have to understand too, when they're going through the divorce process, there are some places that will actually run credit to see, and they have to do this in the exploratory stages to see if anybody has taken on new debt. Some people will liquidate, believe it or not, they will liquidate all of their money before they've planned on getting divorced, and they may hide that money, or they may buy another piece of property without their spouse's knowledge. And so it's not unusual for people to have to go through a process of having their credit checked on both ends. So if that were to happen, that credit card would become her sole responsibility, and it could certainly not be a part of the divorce. I just did one and closed on it last week where he took $60,000 out of their joint checking account. He could not document what he did with that money. And so he was ordered to pay her back 30,000 of the 60 that he took, 50-50. She was getting 30, and plus some other stuff that he had hidden from her. So it always gets found out. But if she has no credit established at all, you know, you might want to do for her, if you're doing something with that, Carissa, maybe just do one soft check on her credit and see if everything is authorized user. Maybe she has some old credit and it doesn't matter. So before you advise her that it would be okay, I would at least take a look at what she's got with at least one bureau on a soft pull.
Okay.
All right, because it could like come back to bite her. She'll definitely be responsible for that herself. And as long as she's not in the state of Texas, she should be okay. But Texas is its whole different entity when it comes to common law and joint credit and stuff like that. So, you know, be very cautious when advising that. So we know that derogatory credit could affect everything. So what do we say makes a successful divorce? When we all get together in our own expertise and we contribute. This is the divorce law. So let's say a divorce attorney calls me up and says, Sandy, she needs to refinance the house. She has 90 days to refinance it. My first response is going to be, Is she getting any kind of maintenance or child support? And if the answer is yes, my second question would be, how long will she be receiving that support? And how old are the kids? So if the kids are under the age of 15, traditionally in Colorado and in most states, they will get the support through high school from when they graduate high school or until they turn 18. So we look at what we call the 636 rule. It's 6 months of receiving maintenance or child support payments and 36 months going forward. So if they want her to refinance in 90 days and she needs the child support or the spousal maintenance to qualify, she needs to have shown and documented that she has received 6 months of that support up front. So I would say, can you buy her 180 days? Can we? Because if we can do that, we can save the house and we can keep the kids in the house and nobody has to be uprooted. 90% of the time they come back and say, yeah, we can give them 6 months so that you can do it the right way, because they don't want the kids disrupted and they just don't know that you can use child support or maintenance to qualify based on our 636 rule. So that is like one of the biggest things that attorneys call me. How long do we have to wait before they sell the house, or how long do we have to wait before they can refinance it? So time frame is very, very important when you're working with these 4 pieces of the puzzle. The same thing with tax planning. Is there going to be capital gain? If it is a court-ordered stipulation, chances are there will be no capital gain when it comes to 401ks. When it comes to values, I always say this: it's very nice if both parties want to contribute to appraisers and pay $800 for independent appraisals. But if there's going to be an equity buyout, there is only one appraisal that is ever going to matter, and that is the appraisal that we do in the equity buyout. So it is better to get a CMA from a real estate agent on both ends. Independents, they're still independent, and then use the appraisal from the bank, because it is definitely, we can't talk to appraisers. It's going to be, not leaning towards one person or the other, because you're going to have one party that says, I want my house to appraise for a lot of money, and another party that says appraise it for the least amount possible because of the equity buyout. One wants more, one wants less. Follow? So if they can get away with just doing a CMA from independent realtors to determine an estimated value, the only appraisal that's ever going to count is our appraisal. So we want to look at the journey of a divorcing homeowner. What are their needs, wants, and needs? Do they want to retain the marital home? Do they want to sell and buy a new property? Do they have children? Is there stability that they need for the children? Are they in high school? Do we want to postpone selling the house until they all graduate from high school? And of course, what can we afford? And then you go from your wants and needs, you're going to go to your facts and options. What is the value of the real estate property? What is the equity buyout? What is the lump sum payout versus support? So when we say lump sum payout versus support, there are many times that a couple would rather not do the monthly support and just have a lump sum payout and be done. Again, if they get a lump sum payout and they want to buy a new home and they, are income poor, this is an opportunity to take that lump sum payout, put it in a revocable trust, and now they have control over their income and how many years they'll be receiving that income. And we just look for 3 years forward. Verbiage is one of the most important things that I talk to my divorce attorneys about. Assignment of debt. Who's getting what? So let's talk about that. You have 2 cars, all right? One car is going to the husband, the other car is going to the wife. They both have car loans and they're both on those car loans. They cannot refinance their names off of the car loans. As long as the attorney in the divorce stipulation puts down Toyota 4Runner, loan with US Bank, VIN number of the car, the VIN number to identify the car on both, and on the other side, you do not have to hit them with that car payment if it has been assigned to the other party. All right, and that is really important. But from our standpoint, we need to be able to match up the car to the car loan, and because there are more than one Toyota 4Runner out there, all right? They're all over the place. Can't just say it's a 4Runner. I got the 4Runner. Well, how do I know that's the same 4Runner? VIN number. VIN number will always identify the car. How do I know that's the auto loan with US Bank? We can get them to put a partial loan number in the divorce stipulation. That makes our jobs even easier. But the bottom line is, whether it's a credit card or a car payment or a mortgage, as long as it is put in the divorce stipulation and it is recorded, we do not have to hit them with the other person's debt. It has already been court ordered and assigned to the other person. So as long as they're not trashing each other's credit by not making those payments, you do not have to hit them with that monthly payment, ever. So that's really, really important to know. If they say, oh, we've got all this joint debt together, it doesn't mean that you can't qualify. It just means that you have to qualify who is in charge of paying what debt. Make sense? Any questions?
I just have one. Jumping back to the 401k being put in a revocable trust. So if they do that, are they required to continue to take that payment until the 401k is gone, or is it 6 months and they can, because that's the retirement?
It's not 6 months for that. It's only 1 month. So when you're putting a 401k into a revocable trust, it's still a 401k. They will still have to pay taxes on that money. We, for the purposes of lending, only need to see them take one payment. What they do, Annette, after they close on the loan, is between them and their conscience. If they choose to use a different source of income to make that mortgage payment, the biggest thing that we care about is that they got that money. And they would, and they have the ability to draw from that money. The trick, it's just a trick. See, if it was just a regular 401k, they might look at it a little bit closer, but once it's in a trust, you are in control of your own income earnings. So for a trust, and it has to be revocable, must be a revocable trust, and they must be 100% in charge of that trust. So if they say, I'm going to assign myself $10,000 a month, and they close on the loan and say, okay, I'm not going to take that 10,000 right now, I'll wait. That's on them. They can do that. We can't tell them that they have to take it. Child support and spousal support, because that is specifically coming from the other party, must be exactly the amount that is stipulated in the divorce decree. If the divorce decree says they are getting $2,500 a month, we need to provide 6 payments of receiving $2,500 a month. They don't get to sit there and say, well, he owes me $300 extra for health insurance, or I gave him a credit of $300 because he paid for the childcare. You cannot do that. They have to, it has to follow what the divorce decree says. What you do after the 6 months and you've closed on your mortgage with your ex, that's between you two. But well, if you need to use the income, it has to match what is in that stipulation. They cannot just change it at a whim. I'm only giving her this much because I had the kids for, I don't care if you had the kids for 2 months. The court order said You have to pay her $2,500 a month. You don't get to change that. If you want that changed, guess what? You got to go through the courts. So once they make a change, then the clock starts all over again. So that's where it's really important to understand that the divorce, maintenance, child support, those 6 months that they're getting that we have to show has to coincide with what's in the divorce stipulation. Oops. There we go. Okay. So we look at qualified income sources in the mortgage industry. So I'm not trying to teach you guys mortgage 101. What I'm trying to do is just give you a higher level view of issues that kind of get overlooked when you're dealing in this type of situation. And it's just enough knowledge for you guys to understand that there are different ways to do this. So one of the biggest areas, of course, is the course of income, like qualified, what we considered qualified income. So gaps in employment and part-time versus full-time, of course, is always going to have still an impact on whether they qualify or not. We know that if they have more than a 6-month gap of employment, that they may have to be back to work for a certain amount of time before we can use that income. Or if they have gone from full-time to part-time, that technically they need to be part-time for 2 years because we have to income average. Those things aren't really going to change from day to day. We still have to follow our guidelines. It's the support income that I was just discussing that we have a little bit more control over, where we can make that qualified income sources. And so you have to follow that 636 rule, okay? Alimony, maintenance, child support, whatever the hell they want to call it, must be received just for at least a minimum of 6 months. And if it's not through the courts or being garnished through their pay and they're paying it directly by check, you need to provide 6 months canceled checks. The lump sum payment, that's completely different. We put it in a revocable trust, we assign it, boom, there's your qualified income source. So we can take unqualified income sources and actually turn them into qualified income sources per Fannie, per Freddie, and per the FHA. So again, we're talking about the 636 rule, must be met for all support and income to be considered qualified. They're looking for the stability. They're looking for consistency. They're looking for the paper trail. Okay, and again, it must be the full amount each month per the court order. So I cannot express that enough, because couples get divorced and they make their own rules, and that's wonderful if that's what they want to do, but then they're jeopardizing that potential qualified income source.
Okay, and quick thing on that.
Mm-hmm.
You can't use just the divorce decree stating that it's going to be that much in for 36 months or whatever. I guess what I'm trying to say is, can they, right after their divorce, go ahead and purchase a home, or do they have to have that 6 months track record?
They have to have the 6-month track record and that to use that income. Now, if they qualify without needing that income, then it's a moot issue, obviously. But if they need that income to qualify, and the best example I can give you is a stay-at-home parent. I have stayed home with the children for 3 years. Okay. There's a reason why you get maintenance. Okay. Now, the first 5 years of a marriage, generally speaking, you're not going to get much. You might get 1.5 years of maintenance. But traditionally, if you've been a stay-at-home parent and you have been married for 10 years, you are entitled to get at least 5 years of maintenance until you can make yourself whole and get back into the workforce. So the idea of maintenance is really to help to give that partner time to get back out there and get a job. But as long as it's 3 years moving forward, you get to use that. Same thing with the child support. But again, if you can't document it, you can't use it. They're not going to just take the divorce paper, because there are so many people out there that get divorced and it says you got to pay X amount of dollars in child support and they don't pay anything. And so that's why they can't use just the divorce papers, unfortunately. So again, we have to, as a, you know, in this industry where we are at, we have the ability to be able to create qualified income sources if we can get in on the ground floor with the divorcing couples and get them that information, which is why I do the workshops once a month for the community. They're specifically for people who are contemplating getting divorced, not in the middle of getting divorced or with a divorce attorney, but people who are contemplating, I don't want to be married anymore, but I'm not sure what my rights are. All right, so we're laying the groundwork to try to help other people in the industry be able to help divorcing homeowners. We're not here to like corner the market. I really truly just want to give this information out to everybody to protect people from getting into, like what happened this morning, poor choices about how to handle a divorce situation that is putting them now in a situation where they're committing a potential fraud by using another person as a straw buyer. So I feel like if we can share this information, that we can help your friends, your divorcing clients, and help yourselves to know how to better structure the loan. And you guys know that you can always reach out to me if you have a situation like this, and I will guide you through the whole process to help you get it done properly and so that everybody comes out whole. So we talked a little bit about the court order assignment of debt. So of course, there's always going to be issues with the division of debt. No surprise, right? Not a surprise when people are getting divorced. They're no longer playing nice in the sandbox together. And I know that when I was married, my husband used to be like, why is our credit card bill? I don't use this credit card. It's like, dude, we have kids. They're expensive. We don't always have the money. So yes, most of the stuff on this credit card I did charge, but it wasn't for me. It was because our kids won't stop growing. I mean, my son grew 8 inches in 1 year. Can you imagine, like, his feet, his clothing? I mean, it was like, I swear to God, every night he went to sleep and he'd wake up the next morning. I'd be like, you grew again. Stop it. I can't afford this. You know, and that's like when you get into an ugly situation, that's where the spouse could say, that's her credit card. She charged all of that. I had nothing to do with that credit card. And then she challenges back, no, that was for the kids. And so it becomes, you know, what the judge has got the final say as to who's going to pay what. But when one party is ordered to make the payment on a specific debt, that is considered a court-ordered assignment of debt, whether it's the mortgage, the car, or what have you. So when you hear people say, oh, I was assigned, I assumed the mortgage. They didn't really assume anything. They were assigned by the court, by the judge, that they have to make that mortgage payment, thus making it easier for you to go out and buy another property because you have the divorce stipulation that says they have to make that mortgage payment. In that particular case, Annette, that is when the divorce decree is all you need. You don't need to get canceled checks to show they're paying it on time. We know they're paying it on time because it's still showing on your credit. You only need the divorce stipulation to say, yeah, I'm not responsible for that car payment. I'm not responsible for the mortgage on our second home. And that's where the divorce stipulation can be used. Never for income, but to definitely to offset those liabilities against them when they're trying to qualify. Now, if it's a 50-50, then you only have to assign them 50% of the debt. So that's kind of cool also. So we have people that go in on boats and stuff, And it's like, oh man, why did you buy a boat? Now you got $1,000 a month payment. Yeah, but I'm on it with 3 other people. Well, you know what? Until you've all to one person has made that payment for 1 year, we got to hit you with that debt. But in this particular situation, as long as it's been decided by a judge and recorded in the courts, we don't have to worry about that. 50-50, 100% his responsibility or hers. It all plays out to help them qualify. So when one spouse is going to retain the marital home and they're acquiring the ownership interest of the other spouse by paying them their share of equity through a refinance, we call that an equity buyout. And this term is really confusing sometimes into thinking that it's a purchase when it really isn't. Even if the spouse is awarded the home who was not on the current mortgage, it can still be done as a refinance. Now, Fannie Mae came in and Freddie Mac too, and kind of said, once deed changes over, you got to wait a year to do a cash out refinance. And this is where an equity buyout is not considered a cash out. So you are taking $100,000 of equity. That $100,000 is specifically, think of it as a first and second mortgage on the house. You have your first mortgage, and then the spouse who's getting the equity buyout then becomes the second mortgage. And they don't have to have that 12 months because it's not considered cash out. So it's a gray area. We're still working it out with Fannie and Freddie to make sure they're still going to honor it. But so far they say they are. And so that would be an exception. Now, if they're doing an equity buyout as a refinance to buy out their spouse, they cannot take other cash out. They want to pay off other credit card debt. They want to pay off their car loan. If they need to pay their attorney $20,000, the second they go beyond the equity buyout of $100,000 plus whatever their closing costs are, now they have made it a cash out refinance and they have canceled out all of the court ordered stipulations with regards to the equity buyout. They can no longer get, so when you do an equity buyout, you get no cash out pricing on your interest rate. You do not get cash out pricing. You have to call secondary and say this is an equity buyout divorce, and they will go in and they will manually change the pricing on your loan to a no cash out. The other thing is that you can do a no cash out refinance as an equity buyout up to 95% of the loan to value. You are not capped at 80 or 85. You now can go up to 95 because it's court ordered. But again, you can't pay for your attorney out of it. You can't pay off your credit card debt. The only equity you are allowed to take out is what it says in the divorce stipulation to satisfy making your divorcing spouse whole with the equity buyout. So questions on that?
Yeah.
Go for it.
Okay.
Let's go.
So when you're structuring this,
Mm-hmm.
are you structuring it as a cash out and then you have to call your rep to say, hey, this is an equity buyout, and that's where you can.
Right. So when
Okay.
you're submitting it, it's a little weird. And I will tell you, if you have to do Freddie Mac, all right, do not go to UWM. UWM does not understand Freddie Mac's guidelines when it comes to equity buyouts, and it's a verbiage that they have in there. So you may have to go to a Remen or somebody that works with Freddie Mac. UWM will do it with the FHA. They'll do it with Fannie Mae. They have not, they don't understand how to do it with Freddie Mac, so therefore they just don't. It can be done with all three. I'm just saying, if for some reason you had to use Freddie Mac, let's say you had to use Freddie Mac because you need to use the asset depletion program, which is easier than Fannie Mae. You have to make sure you go with a lender that will be able to work with you with the secondary pricing. Otherwise, you could end up getting that cash out pricing. Now, the one I did recently, we unfortunately did have to take cash out. He had ulterior motives. He doesn't want to own this house for too long. It's too close to where his ex-wife lives. So we got him prepared to pull equity out of the property so that in like another 6 months to a year, he will be able to buy a new home and rent out this home that he's living in right now. So we're always kind of thinking ahead also. And like when you get into divorce lending, sometimes you'll get 2 transactions out of it. You might get the refinance and you might get the purchase of the other party. So you know, but it takes time because you're not working with real estate agents anymore. You're working with divorce attorneys, and they don't operate the same way. They don't think the same way. So you know, it's just kind of different when you're working with divorcing attorneys versus real estate agents.
And you don't need a court order to do this.
Yes, you do.
You do. Okay.
That's why you want to get with the attorneys up front. You want to make sure that the verbiage is correct in the divorce stipulation. You want to make sure that they put the right time frame in to cover our 636 rule. So yeah, it has to be court ordered and recorded. So that's why I have to get with divorce attorneys right up front. It's not always fun, Annette, trust me. That's why we started doing the workshops, because the only way sometimes to get to the divorce attorneys is through the clients that potentially will be hiring them. So we are getting more and more movement ahead with divorce attorneys that are now understanding the value of collaborative divorce, because they are now understanding that they know how to get a couple divorced. They know the divorce laws, but they don't know the mortgage laws that they could be using to help those divorcing couples keep that property. So I went over the zero cash back to the borrower. You can't pay off debt. You can't pay off the attorney fees. How do we get around that? Well, it is kind of difficult to get around that. The only way would be is if you get an equity buyout large enough to include your attorney fee and you pay your attorney afterwards. Then you might be able to go into a gray area in that. But the second there is additional cash out to pay off anything other than what's stipulated in the divorce for the equity buyout, you then you changed the pricing on the loan. I went over verbiage, so we understand that the verbiage has to be very specific and the timeframes have to be very specific also. So let's just kind of look at this case study that we put together. So the wife and we're going to pick it apart together. So if everybody can like unmute themselves and shout out what you see might be problems here and there. So wife is awarded the marital home and has to refinance the current loans into her name within 120 days of the divorce being final. The husband has to receive his equity share of $111,500 upon the refinance based on their current divorce appraisal. The wife has been given $500,000 of the husband's 401k via what we refer to as a quadro. Their joint marital debt is $8,000 owed to Visa to be paid out of the equity in the home by the wife. The husband is to pay $1,200 a month in spousal support. The husband also has to pay child support of $800 monthly until the child turns 18 in 2 years. So let's take this piece by piece. First one, wife is awarded the marital home and has to refinance the current loan into her name within 120 days. What would be a better time frame?
180.
That's right. Now, if we'll go down further, okay, so technically we'd like to see 180, but that 120 may not be a problem. All right, so now the husband's got to receive $111,500 upon the refinance based on the current divorce appraisal. But what appraisal actually is the only appraisal that's going to count? The appraisal that the bank orders. So if his appraisal is higher than the bank appraisal, that may affect the buyout, which is why it's nice to know that she can do up to a 95 LTV in that particular case. All right, we talked about the wife getting 500,000 of the husband's 401k. So if she gets 500,000, what can we do with that money?
You put it in the revocable trust for income.
Right. And then how many payments from the revocable trust do we need to get?
1.
And how many years do we have to, let's say it's 10,000. How many years forward does that $10,000 have to go?
3.
3. So she would need at least 360,000, right? To make that work. So she may not have to wait the 120 days necessarily. It depends on what the price of that, what the value of the house is and what the mortgage is. So maybe we don't need to worry about the 120 days.
You can choose to not put that in the revocable trust too, though, right?
I'm sorry, say that again, Annette.
She can choose to not use that as income.
She can choose not to use the 500,000 as income. She can choose to put that right back into her 401k and not put it in a revocable trust. And she can choose to make him wait the 180 days so she can use the spousal support, which she'll be getting for life. But $1,200 a month versus $10,000 a month may not be enough for her to qualify. Now we've got the joint marital debt, $8,000 owed to Visa to be paid out of equity in home by wife. So what would be the best thing for them to do with that $8,000? They could have that $8,000 put into the equity buyout and have that $8,000 in the equity buyout assigned to the husband, and he could pay off that $8,000. Make sense? So that she doesn't have to be hit with that monthly payment. The marital debt of $30,000 to American Express, that's going to be 50-50 as long as it's stipulated correctly. We only have to hit her with half the payment because she's only responsible for half. What's the problem with the last one?
Only 2 years.
Right. It's only 2 years. And so unfortunately, we can't use the child support because the child turns 18 in 2 years. Now, there are some states that will extend that child support to when they graduate college. If it's stipulated in there, then you have something to work with. Jennifer, did you have a question, hon?
Oh, no.
Oh, okay. You popped up, so I thought maybe you did. Okay, so how are we up? We got 3 minutes left on our time. So basically, we would have to look at the full amount of what the balance is on the mortgage to determine if she needs to wait that 120 days to use the $1,200. Most likely, Annette, she would have to put that 500,000 in a revocable trust to make it happen. And then she can do whatever she wants after we close. And putting things in a revocable trust, by the way, guys, is a really, really, really good idea. I have everything in a revocable trust. It kind of saves you from probate. I advise most of my borrowers that after they purchase their home, that they should put it in a revocable trust. For people that have teenagers who get into a bit of trouble sometimes, they can go after our property. They can go after our house. But if it's in a revocable trust, they can't go after the property. So a revocable trust is not just for Quadros 401ks. I have everything in a revocable trust. My house, my 401ks, my bank accounts, it's all in a even my car is in a revocable trust. I have been through probate 3 times and I don't care to ever see my children go through it. It'll suck the life out of you. And when there is a simple solution to it, it's easier, and you'll be a hero to your people if if you give them that one bit of extra advice to put it in that revocable trust, because it will protect their estate, and it'll really protect their family. And it comes with a will, and you can't beat that. So questions for today's training? We got like a minute. Although
When
I'm
you're putting that
telling
money
you.
in a revocable trust instead of rolling it over into a 401k, does that not make it taxable?
Yes, it does. I said that earlier. It will be taxable income, but you can put a 401k in a revocable trust. But every time you are taking from that 401k guy, yes, it is taxable income for sure.
But if you do that other first and then roll it into the trust, you're okay.
Right, exactly. So
Okay.
what you do after you close on the house, that's up to you. You have the money. We know you have the money. You took a draw of $10,000. We can assume that that's what you're going to be taking. You're going to pay taxes on it. That's on you, not on me. What is waived on a quadro is a early penalty for having to liquidate it because it was court ordered. So they can roll it right over into a 401k, still put it under a trust. And if they don't need to draw from that, they don't have to. I'm just saying that there are ways that we can help them keep that marital home or help them get into a new home by using these lump sum payouts. But yeah, it's definitely a taxable occurrence for sure.
And then you, in this example, you had the wife paying that $8,000 credit card, and then saying you could have the husband pay it out of the cash that he's getting.
Right. So they could have negotiated it different, that the wife give the husband an additional 8,000 in the equity buyout. And then the husband could have taken responsibility for that credit card. And it wouldn't have had to have gone through for the wife against her. The American Express debt, because it's stipulated 50-50, she'll have to be responsible for half that payment. So that I'll have to go through her. So, and these are common, and this is where we say, like, it sometimes is better to have the other party get a higher equity buyout if you want to buy another house and you can't afford to have those debts against you. So our whole thing is to make sure that we give enough information, not just to the people that are getting divorced, but to people in the industry, so that they don't make certain mistakes unknowingly because they didn't think something could be done. Like, people don't know that you can go up to a 95 LTV and pull the equity out for that buyout. They're just assuming it's capped at 80 because it's a cash out, because in our mind, that's how we're trained to think. And so if we can get some of this information out there, then people that aren't certified divorce lending professionals still can do justice by their borrowers, and get them into the right program. And unfortunately, our lenders who are aware of this don't intervene. They just let you put it in the way you want to put it in. They're not going to say, oh, you don't have to put it in as a cash out refi. If you take this out and you just do the equity buyout, we can give you a better interest rate. It's not in their best interest to offer that. So we have to know what they may not know or may not want to share with us. Other questions? Anybody? Anybody? We done? Carissa? All right. Well, I will see y'all on Friday. Jennifer, just let me know what time you want to come in, but it'll just be basically you and me, and we can go through all of that stuff. And you all know if you have questions about anything, you can always come in 10:30 to 12:30. We will be changing hours come October, when this series is done, and then things will be a little bit different because we'll have a lot of recordings. And so some of this training can be accessed all the time. And then you can just replay stuff. So we're still working on getting everything finished on the website. But for now, I'm here live for you, whatever you need.
Already.
Thanks, Andy.
Thank
All
you.
right, you all have a great rest of your day.
See you. Bye-bye.
Thank you so much.
Later.
Bye.
Bye.